organised by the Oxford Prospects and Global Development Institute. On behalf of the Institute Director, Dr. Shidong Wang, I would like to acknowledge our gratitude today to the Beijing Normal University for their partnership in organising this session, and in particular for the support of Professor Song Shangping, Dean of China Institute of Education and Social Development at Beijing Normal University. The four conversations in this series, of which this is the third, are exploring some of the challenges in our current global context, where social, political, economic and ecological challenges are intersecting and intensifying divisions within and between nations. Academics and practitioners from a raft of disciplines, law, sociology, ecology, and international affairs, are each offering expert analysis of the complex nature of conflict and division, and considering what the prospects are for these challenges being transformed into opportunities that will build and restore trust and cooperation. Today's theme is rebuilding trust in law and order, and looking especially at the role played by restorative justice, itself a contested subject. What role does it play in restoring trust in law and order? The problem of crime is, of course, universal and as old as civilization itself. Hence, every government is responsible for ensuring that the criminal justice system operates within its sphere of influence fairly and effectively to deal with crime and wrongdoing. This responsibility is complicated, not to say the least, because concerns over how best to maintain law and order, to prevent crime and to reduce recidivism are contested questions amongst lawyers, policymakers and citizens. Against a global backdrop of rising crime rates and growing prison populations, restorative justice represents a different way of responding to crime and wrongdoing. Its advocates claim that its unique approach to sentencing and dispute resolution offer new possibilities for restoring trust and efficacy in criminal justice systems, and for responding proactively to problems of prison overpopulation and recidivism. Restorative justice is currently practiced in at least 40 countries worldwide, but the term itself is contested. So what is restorative justice? Our panelists will no doubt help us in that basic question. Our presenters are legal academics with specialist knowledge about how restorative justice is regarded in their respective countries, the UK and China, and what specific opportunities restorative justice poses for criminal justice in these two legal jurisdictions. Our presenters will each begin by highlighting some of their distinct characteristics and emphases of restorative justice from their experience and their context. And then in conversation together, they will probe and go a little bit deeper into the challenges and opportunities that RJ presents to their context. Let me, before we go to the conversation, introduce our two esteemed panelists. Firstly, Professor Shumei Wang currently serves as Professor of Law at Beijing Normal University and is Vice Dean of the College for Criminal Law and Science. She has worked as Deputy Procurator General at Fangshan District Procuratorate of Beijing and as Adjunct Judge at the Supreme People's Court. Prior to joining Beijing Normal University, she worked at The Hague International Criminal Court's pretrial chamber and as Associate Professor of Law at Renmin University of China, and as well as Judge of the Tianjin Intermediate People's Court. She holds a PhD in law from Renmin University of China, was a visiting scholar at New York University School of Law, a global research fellow at the Hauser Global Law School program, and a Fulbright scholar. She now currently serves as Vice President of China Association of Integrity and Law, Vice President of the International Association of Penal Law, editor of series on international criminal law and the Howard Journal of Crime and Justice, Board of Directors at the Syracuse International Institute for International Criminal Justice and Human Rights, and on the steering committee at the Geneva Academy for Anti-Corruption integrity and good governance. She has published, you will not be surprised to hear, 180 papers and authored 45 books. I cannot believe she has the time to be with us. We are extremely grateful to you, Professor Wang, for your time today. And to be in conversation with her, I'm delighted to welcome Dr. Kerry Clamp. Dr. Clamp is Associate Professor in Criminology at the University of Nottingham. Her research focuses on the application of restorative justice within transitional settings, within police, and in the community. She is the author of Restorative Justice in Transition and of Restorative Justice in Transitional Settings, and Restorative Policing, Concepts, Theory and Practice, co-authored with Craig Patterson. She currently sits on the International Advisory Board for the International Journal of Restorative Justice, and she has always had a strong interest in practice and a desire to reduce the boundaries between academia, practice, and policymaking. To that end, she is the editor of the newsletter for the European Forum for Restorative Justice and is chair of the editorial committee. She is currently chair of the Board of Trustees for the Restorative Justice Council. Her monograph series with Routledge, entitled Contemporary Issues in Restorative Justice Practices, creates a unique platform today for practitioners to share skills and techniques at the forefront of the field. So our panelists come with an enormous experience, and we look forward now to hear from them. I echo the introductory comment. Please put your comments and your questions into the chat box as you listen to our speakers, so that your contribution can also be registered in the latter part of the discussion. I turn now quickly to both of you with a very brief question, so that we can get a sense of you as an individual. Professor Wang, first of all, where did you first encounter the concept of restorative justice? What inspired you to invest your time and energy as an academic to this subject?
Okay, thank you for your all the kind words. And actually, when I wrote my dissertation on International Criminal Court, I found the innovation trial format is a gacaca trial after the mass killing happened in Rwanda, the Hutu and the Tutsi, the genocide. So after this mass killing happened, I found the gacaca trial was in some instance with the characteristic of restorative justice. And it rose my attention to this field forcefully. We all know after Rwanda mass killing, there is a Arusha trial and the National Court, and the in fact, it's at the beginning, maybe because of the lacking judicial resources to have to conduct this gacaca trial. But in some instances, it's like more victims participate on this trial style. Is like a trial on the hill. And even though there is, we all know a lot of defeat, like unprofessional, but it's kind of, for me, it's kind of beginning to realize there's a new pattern of the trial style, all the restorative justice. So then recent years, China start to judicial reform in criminal matters, and especially the conciliation in criminal cases make me think a lot on the RG, and I know there's more room for further study at the beginning, start to this restorative justice in China.
Thank you so much. That's great to hear where the inspiration has come from. Dr. Clamp, can I ask the same question of yourself? Where did you first come across it, and what inspires you to give so much of your career to this subject?
I have a slightly different story. I was in my second year of my undergraduate degree, and we were in Johannesburg in South Africa, and we were offered an opportunity to get involved in a restorative scheme. And I just thought that it was mad. I just didn't understand it. I had a very punitive mindset. I thought it was utter nonsense. And that motivated me to learn more so that I could critique it more. And actually what ended up happening is that I bought into it like hook, line and sinker. And I think that that very often happens, is that often the biggest critiquers of anything, when they get something, become the biggest advocates. And so I am pro-choice. I think that we should empower individuals to make decisions for themselves. And I think that our social constructs of victims as defenseless and harmed and offenders as predators is problematic, because in reality, there is a lot of gray in there, and just locking people up, we know, doesn't work. So anything that is going to help us move forward in a productive, healthier way, I'm all in for that.
So let us now harvest the benefits of your long-term study on this, and particularly your experience in restorative policing, as we listen now to your presentation.
Thank you so much.
Thank you.
Sorry, just give me 2 ticks. Can you see that, Mara?
Yes.
Okay, great. Thank you so much. Come on. There we go. Right, so good morning, everybody, and thank you so much to Mara for arranging this conversation and for inviting me today. It is an honor to be asked to participate in this dialogue with Professor Wang and to share my research with all of you, so thank you so much. So what is restorative justice? Well, broadly, it's a philosophy that argues that those most affected by an incident are best equipped to deal with both its causes and its consequences. And as such, empowerment and participation are core values of restorative justice. In England and Wales, all victims have a right to information about restorative justice with the new Victims Code, which will come into effect on the 1st of April. And this is available at all stages of our criminal justice system, from pre-sentence minor offences to post-sentence serious offences that could involve murder, rape, and other violent and property offences. You will often see this diagram when restorative justice is discussed, because it runs home the centrality of the victim, the offender, and the community. And when I say community, this could be those more broadly affected in a geographical area, or those that have a pre-existing relationship with either the victim and or the offender. And they have a central role to play in securing justice, and so that is what it is about. But a central defining feature of restorative justice has always been about deprofessionalizing justice, right? So we have to ask ourselves that question: what role then is there for state agencies such as the police within this? And this has produced a heated debate over some 30 years now, really, about the role that police should or could play in restorative justice. On the one hand, in order to be true to the core aims of restorative justice, historically, some have called for restorative justice programs to remain separate from the criminal justice process. In particular, this is underpinned by by the belief that police officers will instinctively co-opt the process to achieve traditional policing objectives, those of crime control, as opposed to restorative ones, so those of community control. Some have also argued that oppressed minorities might benefit less given the cultural differences in interaction. So there are studies that talk about police not being able to interpret remorse and such like from other cultures that are different to their own, and obviously over-policing. And we see this as a worldwide phenomenon. People with criminal records are very often excluded from restorative justice, right? So that's something always to be conscious of. And finally, that the police just do not have sufficient time to devote to restorative justice approaches. On the other hand, however, proponents and experience suggest that if police are not involved in restorative justice, there's actually very little challenge at all to the status quo of how crime is dealt with, and that independent schemes will very often to attract the referrals that they need to remain operational. So the police are really pivotal in this regard, given that they are the gatekeepers of the criminal justice system. They determine which individuals and actions are diverted away from the criminal justice system or into it. And as such, proponents argue that restorative justice improves services to victims, to offenders and communities, thereby improving police-community relations, but also importantly, police staff morale, because they can see a positive outcome in what they're wanting to do. And it also offers significant opportunities to change or to begin a shift in police culture. So in 2018, my colleague and I conducted a national survey to review how restorative justice was being used across England and Wales. And we found extensive use of what is called the New Zealand model, whereby police refer suitable cases to independent organizations, and the Wagga Wagga model, which in essence is where police officers themselves are trained and they facilitate those restorative processes themselves. So to give you a visual of what restorative justice provision looks like in England and Wales, this diagram shows a tendency to talk about it in different levels in this country. So level 1 is very often referred to as street restorative justice, or used on the spot to respond to minor offending, often in conjunctions in a police settings with community resolutions and out-of-court disposals. Level 2 is where officers or external providers will use face-to-face conferencing or shuttle mediation, whereby messages are delivered to affected parties by a trained facilitator. And at this level, restorative processes are used to deal with more serious or persisting offending, non-crime, antisocial behavior or neighbor disputes, and thus takes place at both the pre and the post-sentencing stages of the criminal justice process. Now, level 3 is reserved for the most serious and complex offences and is usually conducted post-sentence, where an offender is serving a custodial sentence or has recently been released. When it comes to policing, there are several cultural and practical considerations to this, however, that limit the amount of cases that are dealt with by way of restorative justice and the extent to which police culture is shaped by restorative justice. And the first is that frontline officers are trained in a catch and convict mentality, wherein they position themselves as protecting the goodies from the baddies, right? And operating outside of this binary way of thinking is generally not something that is welcomed, because it complicates their understanding of their role. Secondly, they lack the skills to operate restoratively. And what I mean by this is, people who know me and have heard me speak about this before, if police officers get restorative justice, you don't get any better practitioner, in my view. So this shouldn't be taken in any way, shape or form that I'm not supportive of this. But what I mean by saying they can't operate culturally is this is the culture of policing leads officers to take control and to make decisions about what is important in an incident and what should happen as a result, right? So that kind of giving ownership over to other people is quite a challenging thing. And giving their power away, given that giving their power away is not something that they necessarily feel comfortable with or know how to do, this presents a real practical challenge to the implementation of restorative justice within policing. And finally, restorative justice approaches require us to engage with emotions to understand how they might be driving behavior. Now, this is counter to our ingrained socialization, which tells us that criminal behavior is a rational choice, right? And that's why we punish people. And this thinking dominates policing as well, unsurprisingly. And this will mean that very often the police will perceive restorative justice as a soft option, or in other ways, not a meaningful way to deal with offending. As such, you cannot change policing without acknowledging that the beliefs and behaviors of society and police officers will play a huge role in how they do their jobs. And this is significantly influenced by the culture of the institution within which they work as well. So if we're keen to introduce restorative justice into policing, we need not only acknowledge this, but find ways to challenge this. So in a bid to explore how a deeper understanding of restorative justice might have a more significant impact on policing practice and culture, I collaborated with the sergeant who developed restorative policing initially in Australia, and we sought to train police officers in restorative justice skills and theory. And my evaluation of this training yielded some really interesting insights. But it's important to note that this was only an exploratory study, right? A pilot study. So we do need more sustained research in this area to ascertain the full potential of restorative justice training and practice for frontline officers. And we all know the problems with resourcing, etc., in that. But the initial training was an introduction into what was known as restorative questions, or a script, right? And officers were given these cards to structure their conversations with both victims and offenders. And my interviews with police officers revealed that the cards enabled them to meet victims' needs more effectively, and also that they were more effective in eliciting voluntary confessions from offenders, and that it gave new recruits more confidence in developing their own policing style, rather than looking to how more senior members of staff conducted their jobs. So that was really great. Officers were also introduced to the theory of emotions, which is often drawn upon in restorative justice training more broadly. So this included Fair Process by Kim and Marborn, The Compass of Shame by Don Nathanson, and Techniques of Neutralization by Sykes and Mutzer. And essentially, these theories provide insight into how emotions drive both actions and interactions, and thus empowered officers to notice where this was happening and to alter their interactions with participants, the community, suspects, victims accordingly. And my interviews revealed the potential this had for more effective interviews with suspects, and also, unsurprisingly, reductions in assault on police officers, because they weren't contributing to heightened emotions with people that they were dealing with. They were able to lower the tone to get people to speak more logically as a result. So the core elements of restorative policing continue to recall Robert Peel's 9th principle of policing, which says the test of police efficiency is the absence of crime and disorder, not the visible evidence of police action in dealing with it. And achieving this involves more effective interactions and outcomes between the police and the communities that they serve. And I really see restorative policing as an effective way in which these ambitions can be achieved. Thank you so much for listening to me. And Jumei, I really look forward to learning from your experience. Thank you so much.
Thank you, Dr. Tam, very much. Professor Wang.
Yes, I first share my, okay. Oh. How? Okay, thank you, Professor Klump. And you are from the very earlier beginning of criminal procedure, start from the police, the offering the cases or the restorative justice, and give more deepened studied and the details. I learned a lot from you. Thank you very much. And now I would like to share with you all of RG in China. Why I start from the culture, legislation, and the practice, because some of the Chinese scholars, when they wrote the papers on restorative justice, most of them think it's like learn from other countries. But here I start with the culture. I want to emphasize that in Asian China, there are a lot of practice in restorative justice, either in like administrative way or in a criminal justice. So now I would like to start with my slides here. You can see the first slide. I also use you can see the Chinese character is a he wei gui, is actually is the very fundamental value of Confucians cherish is a harmony. So the Confucians influence almost every corner of Chinese people's life. It puts way of Li. Li is courtesy, politeness, good manner, and elegance. And the center of its philosophy and believes that the most valuable things in Li is harmony. So it is to use fair, justice, appropriate way, and reasonable middle principles to solve the conflict between the man and the nature, man and the society and the people. It can be said that the harmony has the similar meaning or value with restorative justice to restore the social relation and maintaining the social stability. So in this, Confucian's philosophy impact the ancient Chinese law a lot. And there are also, you can see in Tang Dynasty and the Qing and the Ming Dynasty, and the philosophy of Confucians have great impact on the criminal legislation. And in Tang Dynasty, minor crime between neighbors, such as street fight, was distinguished from other crimes. Those crimes could be settled in reconciliation. And in the Ming Dynasty and the Qing Dynasty, following the special approach, which was established in the Tang Dynasty for fight between neighbors or other minor crimes, it was named as Baogu, and which means the offenders in crime as such must take the responsibility to good care of the victims or pay victim the fee for medicine and a doctor until the victim is recovered from the hurt. And actually the Baogu system contains the influence of the Confucian culture of non-litigation and harmony, giving the perpetrators opportunities for reform and sincerely repent in order to repair the value orientation of the damaged society relationship. So this is also called moral disciplines, and this is also the future in the ancient Chinese restorative justice. And the civil life was shaped by this idea favoring harmony and peace, which repaired people to choose least conflicting with the ways to solve the disputes. And the moral disciplines choose were used to customary law or even codified. However, the judges the ancient judge, who were also the head of the local government in old days and had a very high level of discretion to utilize moral discipline, politically effect were more significant than restoration itself. And the form of the restoration in ancient China did not come to restorative justice, but at times restorative elements played a noticeable role in people's life. And then legislation in People's Republic of China, even though there is no systematical codification of restorative justice in China, mainly the elements of restoration can be found in the area like criminal code, like in the chapter 5 and 7. Because of the time limited, I didn't list in details. And also in the criminal procedure code in the article 142, 290, and also for the protection of juvenile rights in the article 113 and 116, and also community corrections. In these laws, you can trace the practice restorative justice, and is also an innovation approach to deal with the criminal matters. And the purpose or the goal, like Professor Clam mentioned, I don't want to repeat it again, and we all know the goals. But in China, mostly focus on this mediation and reconciliation. So here you can see in the legislation, in the chapter similar to what Professor Clam shared with us, but it's a little bit different. You can see from this chapter, and the victims just participate in this criminal justice, restorative justice, but there's no response to the victim. So victim offender mediation can be in China used to these followings. One is a minor crime, and that could receive the sentence of imprisonment under 3 years and fall into the categories of crimes against personal rights and civil rights or property rights. And this is the scope for application. And the second is to the capable negligence that could sentence to imprisonment under 7 years, except for crimes or misconduct in office. And the third is a conditional non-prosecution can only be triggered in juvenile offense and is limited to the crimes against the personal rights, crime against the human rights, and civil rights, and the crimes against the property rights, and the crime against the social administration, which may receive the sentence less than 1 year's surveillance, detention, and a criminal fine. So the fourth is the accused person may censure remorse, which will be judged by the victim, police, and the prosecutor together. And the fifth is according to China's Criminal Procedure Code, the prosecution is entitled to make the decision whether or not to apply conditional non-prosecution. And the criminal procedure law stipulates that public security organ, people's prosecutory, and the people's court must listen to the opinion of the parties and other relevant personnel, review the voluntariness, and the legality of the settlement, and preside over the perpetration of the settlement agreement for the criminal matters. So this is the victims are this chart not ground enough to the right to speak out and their feelings and needs. So these are the victims in China in the restorative justice. More function is to assist to the prosecutor's job. So then in practice is also in the restorative justice in community corrections. And community correction are applicable to the person who have been convicted and put under civilian probation, parole, or sentences served outside the prison. It means the restorative justice not only start at the investigation or the police involved in, also after the sentence or the serve their sentence may also trigger this restorative justice in China. So the person and the community correction are able to get different kinds of training to increase their employability after the correction, and it's better for them to rehabilitation and better for them to go back to the society. And the offenders need to have more chance to interact with the people in the community as a process of the rehabilitation. And the community corrections can become more educational than punitive, which offer offenders more training and courses to be employed in the future. And regular meetings between the victim offenders shall be established even in the community corrections. And the victims' comments on the execution of the community corrections shall be an indispensable index. So this is for community corrections. And there's also a good practice is besides in criminal justice, is we call it a Fengqiao experience in China. It's the Fengqiao experience to try to settle down the dispute before the application of law. So it's a start in 1960s, a creative model of dispute solving was established in a village called Fengqiao in the Zhejiang province. So Fengqiao experience named after the local location, and to abide by the police from the central government. In general, the mode was more like community justice, where the view of the value and the moral disciplines are based on local culture rather than law. So this model tried to deal with dispute at the grassroots level and not going to the court. And it's also serve a lot of judicial resources. And this mode involves too much local tradition, which is always changing and is shaped by the social and economic environment. So, and then this Fengqiao experience extend to nowadays. The local government organized a special commission in which staff, not only like in 1960s, only from like officials, the staff coming from police, prosecution, and the local civil court, local criminal court, and the volunteers from a community collaborated to resolve these disputes and reported by the local people. And the law goes prior to a local tradition in dealing with the dispute. And the staff in the special commission are well trained and in understanding law and using the legal procedure. And the local civil court and the criminal court consider the satisfaction of both sides in disputes as important as what law is. Judges make the decision based on the local, based on the both legal provisions and the common sense. So this is of the Fengqiao, picture of the Fengqiao experience in new times. So finally, I also want to mention this Fengqiao experience. Although this Fengqiao experience function on local tradition in the beginning, it was created by the national policy from the central government. And the special commission in Fengqiao experience include many people from different departments of the local government, as well as from the local courts. Was the aim at is more than bring justice. There is not law-regulated pattern for Fengqiao experience. Fengqiao experience has become a symbol for practicing restorative justice in China, which is used by many other places outside of the village of the Fengqiao. It's like insisting on the combination of autonomy, rule of law, and the moral discipline is the essence of the Fengqiao experience in recent. And actually in China is like two systems working together, and it's a restorative justice practice plus comprehensive social governance. So it's a restorative justice in criminal matters and Fengqiao experience in settle down the disputes before application of law. So this is what I want to give you the whole picture of China recent restorative justice and influence from Asian philosophy. Thank you.
Thank you, Professor Wang, very much indeed for giving us that much fuller picture of restorative justice in the Chinese context. It's your turn to pose a question to Professor Clamp. What from her presentation would you like her to elaborate or respond to?
Okay, as I at the beginning mentioned that Professor Clamp is a real expert specialized in this restorative justice. I did learn a lot from your presentation. It's really excellent. And I do have a question for you because you study, you make a comparative study, you did a survey and the evaluation, a lot of work in this field. And my question is, because you did a lot, is there any statistic on preventing the offender from causing future harm after conducting this restorative justice? Because restorative justice is kind of like voluntarily. And this question also related to the recidivism of the issues, whether we can evaluate whether the person have the personal dangers if we conduct this, give his leniency punishment, and then he didn't take this license, and how to prevent him for the future. If he think, oh, I just received this lightness punishment, so I didn't feel pain, so whether prevent him for the future crime. And do you have any of the statistic for this? I just want to learn the result of the restorative justice.
Sure.
Thank you.
I think there have been quite a few studies that have looked into recidivism, and I think that there's a broader debate in the restorative justice field, certainly in scholarship, about whether it's appropriate to measure restorative justice against recidivism at all and to have those conversations. You know, in essence, it should be a byproduct of a successful process as opposed to something that we set out to achieve. And we see some quite what phrase do I use? Practices that are perhaps not in the spirit of restorative justice when we start to focus on achieving criminal justice aims as opposed to restorative justice ones. But, you know, studies have demonstrated that there are reductions in recidivism. They are outdated currently. You know, there have been big studies that have been conducted in the UK and Australia and the US and Canada around that. You know, we know that if you send somebody to prison, there's a 70% likelihood that they will go on to reoffend. So we know that prison doesn't work, and yet we don't hold prison to the same level of evaluation and accountability as what we do restorative justice, which seems slightly bizarre. We also know that if offenders, we seem to think that offenders are driven by creating harm intentionally, and we sometimes forget that there are social conditions that have also created that. Right. And if you don't address the drivers of offending behavior, doesn't matter how much you punish a person, they still are going to go back to exactly where they come from, and nothing's going to change. And then the behavior patterns are the same, but now they have a criminal record in addition to that, which excludes them from mainstream society and increases the likelihood that they engage in criminal behavior again. So it's a vicious cycle. You know, I think recidivism is difficult to measure, but I would say that, you know, studies do demonstrate that and it depends on what you're talking about, what the exact statistics are. That's why I'm not trying to avoid giving you an exact answer, but it's tricky business. But, you know, you can have 50% reductions in recidivism. I mean, if we talk about a policing context, for example, where restorative policing first emerged, I'll give you some specific statistics from there. You know, when they train their police officers in this, they saw a 50% reduction in sending cases through to the court. Now, a lot of people instinctively would go, yes, but then you're just letting crime continue, right? Well, actually, there was a 40% reduction in that behavior happening in the community at the same time. So clearly working in a different way and addressing the underlying causes of offending behavior is really important. But allowing offenders to understand the impact of their behavior on other people is really important in getting them to reflect on their choices, I guess, if you want to put it that way. So that's what I would say there.
That's great. Professor Clamp, would you like to return the question to Professor Wang?
Thank you very much. I think, you know, in listening to your presentation, that we're coming, it appears that our nations are coming at this from different perspectives, right? We have a very punitive culture. I'm not saying that there isn't a punitive culture visible in China, but we have a very punitive culture that we're trying to fight against and to introduce restorative justice, whereas the philosophy and values of restorative justice seem to be stitched into culture in China. And so it seems to me that even though in terms of legislative provision or punitive attitudes more broadly, that there is this kind of broad societal understanding and resonance with restorative justice more broadly, the potential for that. So my question to you is, how do you see this then progressing? I know that you have some legislative provision, but in what ways do you think that restorative justice could become more entrenched in China?
Okay, thank you for your excellent question. And China now try best to start this restorative justice in juvenile issues in community correction, and especially in the Supreme People's Procuratory, and they make the decision for the whole country, the entire country will be dealing with the cases committed by a juvenile. So it will be a whole standard, only one standard to dealing with the juvenile issues when, I mean, the juvenile committed this wrongdoing or crimes. And this is the very good beginning. And following the prosecutory and the Supreme People's Court also set up the special court for the juvenile. So there is a star investigation and the prosecution from the prosecutor and the police, and make the final judicial decision by the Supreme People's, by the court. And there is the court system start from the local, intermediate, and the high and the Supreme Court. It's for the juvenile. It's a lot of this practice start in China, and also for community corrections. And we are not want to punish these criminals. The goal of the justice want to repair the damage the society. So we want to this for those person who sentenced to the jail or released from the jail, how to they back to the society. So this is the two ways China try a lot in juvenile issues and the community corrections. And also recent years in China criminal justice, we try like criminal cases reconciliation for the minor crime, for the crime committed by negligence. If the perpetrators really make the confession and truthfully try to pay for the compensation to the victim, and the victim show their forgiveness to the perpetrators, and they before the final decision made by the court, they already reached this agreement, and then the perpetrator and may not put him in jail. It's very good not be for a minor crime, put the person in the jail. He may be influenced by the serious crime perpetrators, and maybe for his future rehabilitation has a very bad influence. So it's also from these separate ways to enhance this restorative justice in China.
Mm-hmm. Okay, great. Thank you so much, Yume.
Thank you.
Professor Clamp, there is a question on the chat room directed to you about policing numbers in the UK, yep, which says, would you respond to this, that the police number, according to media, has dropped sharply since 2009? So how can you ensure that restorative approaches will be operated properly if there are not enough police officers?
I mean, I think that there are two different points around that. So obviously there is pressure on policing and there are increasing crime numbers. So, you know, there is a significant and sustained pressure in terms of workload on police officers that isn't going away. And I think that what we have a tendency to do, certainly in having conversations with senior police leaders, is that we tend to, when we're under a lot of pressure and we're in survival mode, is to keep doing what we're doing, even though we know that it's not working. And what we actually need to do is take a step back and think about how can we do things differently in order to stop feeding the machine, so to speak. The UK has approached that in a number of ways. So in part, it's about exploring innovation in practice and how can we do things differently. But on the other hand, it's about integrating commission services into what we have police and crime commissioners and areas, policing areas, and to have the availability of the private sector or voluntary sector to deliver restorative justice, so to speak. But, you know, I think that in relation to my own work is that I actually argue that restorative techniques and values are more important in terms of training police officers rather than getting them to become restorative justice practitioners, if that makes sense. If police officers were running around trying to facilitate a whole lot of meetings, which in fairness, I have been out with police officers on patrol, and that would take a lot quicker than arresting somebody, which takes a whole shift to arrest and put somebody into custody, surprisingly. You know, that has a significant impact. So I think that there are layers to what we're talking about there, and what exactly it means, what you mean, the person means by restorative justice per se. So, you know, we might be talking at cross purposes, but yeah.
Maybe we can pick that up with Professor Wang. This question of the pressure that police are under with case overloads and with expectations that they will carry multiple roles. There will be, on the one hand, community reconcilers, and on the other hand, law enforcement people. Is that a problem for police on the front line in China?
I don't think so. And I think for the police, they are all follow, they also have their rules for their working, how they to start the investigation and found the crimes. And if there's strong evidence to show there's a crime happened, they will submit this evidence to the prosecutory. And the prosecutory will decide whether the case will be prosecuted or non-prosecute. And then if the prosecutory decided these cases is has a strong evidence to may be trial by the court, and the prosecutory will submit cases to the court, and the court make the final decision. And the police, when they start the investigation and the cases, they may have some pressure from society, from the public. But if they follow strictly of the working rules and to conduct in a very proper ways, and I think, you know, even the officials, when they conduct their in duty, not satisfied with everybody. So if they are from those are not satisfied, we can see maybe it's from the pressure from the public, but they are more work very strictly, follow the rules when conduct this investigation. And also for the minor crime and the juvenile, and they start from the restorative justice, also same as was Professor Kang mentioned, that is start from the police. And it's also following the basic principles of voluntary. And is if the perpetrator voluntarily to make this a confession and compensate with the victim, and there is go the proper ways for this may not be a pressure.
Okay.
Thank you.
There are a number of questions that are coming in that are probing this notion of where is the pressure, and I read by pressure, where is the momentum for bringing restorative justice into the limelight? Where is that momentum coming from? And the flip side of that question seems to be, where is there resistance to it? I wonder if you could both comment on that.
I mean, I think that there is a broad acknowledgement in society that what we're doing isn't working, and that people don't feel that they have a voice, that they have agency, and that they have support. So I think, you know, and I think that that's a relatively uncontroversial thing to say. Certainly the Restorative Justice Council had their second annual conference in November last year. We had a panel of very senior government officials saying that exact same thing. The problem is that there are political blockers in place. So, you know, that we live in a society where criminal justice is a something that affects the outcome of elections significantly, and politicians will be very careful about what they endorse, how progressive they are on the basis of their constituents, and fear of backlash from that. Don't forget that we went through a international financial crisis, and we're just going through another one. So there's always a question of resources. If we're taking money away from one place, where are we putting it into the other? I think that there's a lot of investment going on under the radar, maybe not being used as effectively as it could be, but there are financial and practical reasons why this isn't happening. And I think also there is a lack of public awareness about restorative justice. We need to become much more better in having a public dialogue about this. And the other main consideration is, it's just slipped my mind now, is around the fact that
don't worry, we'll hear from Professor Wang first. Yeah. How would you respond, Professor Wang, to this question?
And
where is the momentum coming from? Where is the momentum, and where is the resilience? Where is the resistance?
Okay, actually, first I want to add that the last question is we also have a community police and officials and who are working inside the community. And for your this question, and any decision cannot satisfy 100 persons. So and also publics, they see the decisions from appearance. But when the officials or police or prosecutor or judges, they make the decision, what they focus and what they found, the concrete facts, maybe the public cannot see that. So the officials, I mean judicial officials, they make the decision on the evidence, on the facts, but the public only see the appearance. So they can't understanding all the legal knowledge, cannot understanding why the judicial officials, police, prosecutor, and the judges make this kind of decision, and on what kind of a circumstance. And for example, if we see this crime committed by minor or by juvenile with the mitigating circumstance, but the public cannot understand what kind of a mitigating circumstance. And they think this kind of circumstance is aggregating. So when the police make the decision, said, okay, these cases, we conduct restorative justice, and the perpetrators pay the medicine or doctor fee for the victim and pay much more compensation for the victim for the future medicine needs. And for the public may think all this kind of pay the money by penalty. So this is from the appearance, but from inside the law, the officials, I think Professor Kamp and me, we trust the officials. They are truly, implement the law and following the evidence and the facts and make the decision. So it's not like the public, what the public said or see is only make the job in duty by the police, prosecutor, and the court according to the law, fact, and evidence. That's my
my other point, Mara, if I can just jump in, was around, I think as a field, we're not very good at articulating exactly what restorative justice is beyond a meeting. And I think that that's the biggest problem that we have.
And from the conversation we've just had, which is coming to a close now, what would both of you say to the possibilities and the potential for increasing or improving restorative justice in your context if there were more of a global debate? One of the first speakers said, do we need a more effective global movement to try to bring to light the strengths and the weaknesses of this subject so that it is not left in the corner in different national debates? We only have a few minutes, so a brief response, please.
I think that is happening. It's just not visible. And I think that that's the problem. Primarily, I think that, you know, somebody else mentioned about having, you know, victims law and rights to restorative justice. The problem is that if you don't have the infrastructure in place to deliver that, it's going to be hollow legislation. But I think that having a broader conversation and thinking very clearly about the role of legislation and policies and discussions in moving society forward to a more restorative existence, if you will, is an important one. And I think that it's a problem in the field again. We're not as visible as what we could be, and we're not having an open conversation with a variety of different people. We're almost in an echo chamber. We talk to ourselves and we all say how wonderful this is, but we're not really having that conversation beyond that group.
Professor Wang, the last word to you.
Yes. And I think right now more and more countries try their best to start this restorative justice and make practice. And not only in individual countries, and also in the international community. And we learn from the UNODC for the international, also for the global society, try to push to practice this restorative justice. As I mentioned at the beginning, even though it's not a really restorative justice in Rwanda Gacaca trial, but it's kind of sort of this restorative justice. And it's especially for the transition society and global crimes and no boundary of the crime, and also the pressure of the jails and very crowded in the jails, and also the perpetrators in jails may influenced by the others, and it's a better way to take this restorative justice to keep these minor crime perpetrators or juvenile or negligence crime committed by the not endangered personalities, and remain them outside the jail is also a very good for the whole society. So from this perspective, I think the restorative justice will be have a very good perspective in the future.
Thank you very much indeed to both of you. And I hope that the audience can be aware that this, if you like, is the beginning of a conversation between the UK and China on restorative justice, because once we get out of this pandemic, we are looking forward to convening, as the Institute here in Oxford, a symposium of lawyers between UK and China to go much deeper into this and related issues. Thank you to you both very much indeed. Thank you to everybody for joining. And don't forget, this time in 2 weeks, the 4th in the series will take place, when we will be looking at another dimension to this question of restoring trust and relationship, this time in the context of trade and economy. Till 2 weeks' time, goodbye. Thank you.
Thank you.
Thanks so much.
Bye-bye.